Hello everyone. Warm greeting to all who have joined here. Myself, MD Fayyaz Alam, a student patent coordinator. First of all, I would like to call Dr. S. Anani ma'am, Dean of Patent, to give welcome address.
Hello, is my voice is audible?
Ma'am.
Okay. Good evening to one and all present here. I am Dr. Anandi, the Dean of Patents, and it is an absolute pleasure to stand in front of you today to extend a warm welcome to all of you on behalf of the MGR IPR and Licensing Center. We have gathered here for a significant event, and I am truly delighted to such a distinguished group of individuals in our midst. As we embark on this event, it is important to reflect upon the powerful words of Nelson Mandela. Education is the most powerful weapon which you can use to change the world. These words remind us of the transformative power of education and knowledge, which are the heart of our gathering today. We are honored to have with us our esteemed event speaker, Dr. Ishrat Meera Mizana, professor from Ufakam Jain College of Engineering and Technology. Her expertise and insights are sure to enrich our understanding of intellectual property rights and licensing. I would also like to extend a warm welcome to Dr. L. Ramesh, the Joint Registrar of Events, Publications and Alumni Office. His presence here today adds great value to our event, and we appreciate his support. And also, I wanted to extend a special welcome to the staffs and students who have come to participate in this event. Your enthusiasm and curiosity are the driving forces behind process. Today, event promises to be informative, thought-provoking, and inspiring. It is an opportunity for all of us to learn, share knowledge, and explore the dynamic world of intellectual property rights. MGR IPR and Licensing Center, which was founded in 2015 and has filed 150 patents and received grant for more than 10 patents. Student Patent Club, established under the umbrella of MGR IPR and Licensing Center, the Student Patent Club is aimed for encouraging and motivating students from our university to actively participate in the patenting process. The primary goal of the club is to inspire students to file 100 patents collectively. This initiative not only promotes innovation among students, but also fosters a culture of intellectual property awareness and protection within the university community. Once again, a warm welcome to all our distinguished speakers and our enthusiastic students. Thank you, and I wish you all a fruitful and enlightening evening. Thank you. Hello.
Now I request Dr. L. Ramesh sir to share his words. Welcome, sir.
So very happy and welcome, Dr. Ishrat ma'am. You are joining with MGR as the, I think, third event.
Yes, sir.
Yes, ma'am. So, ma'am, we had initiated MGR IPR and Licensing Center. Through this, the first initiative, we are planning to inaugurate the Student Patent Club. So while we are directly inaugurating the Student Patent Club, that day we want 10 patents to be filed. After filing 10 students' patent, we thought of inaugurating the club. So that is the idea. So today, students, those who are connected here, all are already they are in the team like alpha, beta, gamma, like that. They will have 10 teams. So these 10 teams already working. 5 teams already finalized the idea, and the remaining 5 teams yet to finalize the idea. So we are presently planning to submit the idea proposal. And then we are going to give some fund for them so that they will do their prototype model within another 3-4 months. Then they will go for the final drafting. So so what actually we needed for the students, because we have consultant, but if they maybe last time we had 1 or 2 patent also cancelled due to the wrong writing. So that is the reason we want you to just inform our students how they will go for drafting the patent, what are the important steps they need to follow, so that this session will be helpful for them. After this session, we are asking them to write a drafting. We are planning to give some 10-15 days for drafting. Then it will be given to the consultant, and then it is going for the next. That is the idea, ma'am. Particularly, we limited the participants today. Only these 10 teams students are participating here. And maybe you can have ask them about their idea also. They will represent them.
Yes, sir. Yes, sir. I'll have an
Thank you,
interactive
ma'am.
session.
Thank you.
Yeah, thank you,
Thank
sir.
you, ma'am.
Thank you.
Thank you, sir, for your motivating speech. Now, I call Ms. S. Devi, patent coordinators, to deliver the profile of event speaker.
Good evening to one and all present here. Myself, Devi, working as a patent coordinator at MGR Educational Research Institute, here to address you with the chief guest, Ishrat Meera ma'am. Ma'am has been working in Mechanical Engineering Department as a professor in Mohafam J College of Engineering, Hyderabad, has more than 2 decades of teaching experience. She has worked on many socio-responsive projects and also published 20 textbooks in the field of mechanical engineering, along with the journal and conference papers. Ma'am has 3 Indian utility patents and 1 Australian patent granted, and published 4 Indian utility patents, and has 5 design patents and 1 copyright registered for mathematical formulation of functionally graded materials. Ma'am has been a regional coordinator for South Central Region for UHV AICTE. She has conducted webinars, seminars in the area of patents, project-based learning, community projects, awareness about sustainable development goals, and technical topics of mechanical engineering. She has received many awards like Peace Award from Smiles Foundation Faculty, Award for Excellence Teaching in Higher Education, presented by DK International Research Foundation. Research Ratna Award of the year 2019 has distinguished researcher in functionally graded materials by World Research Council. Best Women Faculty Award presented by Combined Society for Educational Research and Development. She has been recognized as a research supervisor for Osmania University, Telangana, and KL University, Andhra Pradesh. Also, ma'am is a member of Indian Society for Technical Education, Engineers Without Borders India, and the Institution of Green Engineers, Indo-US Collaboration of Engineering Education, Quality Circle of India also. Ma'am, I welcome you on the behalf of MGR Patent and Licensing IPR Center, ma'am. I welcome you again, ma'am. Thank you, ma'am.
Thank you, Devi madam. Thank you,
Now-
Anand madam. Yeah.
Now I invite the event speaker, Dr. Ishrat Meera Mirzana, to present about patent drafting.
Yeah.
Fayaz, before the Fayaz, you can take later. You can take the attendance so that those who are not joining today, we can remove them from the group. Okay.
Okay, sir. Okay.
Take
I will
it.
take. Okay, sir.
Oh, madam, thank you, ma'am. Actually, I have another one meeting, ma'am. I'm
Yeah,
leaving
no
and then
problem,
continue,
sir.
ma'am.
Yeah, yeah.
Okay,
Thank
ma'am.
you, sir. Thank you, sir. Can I have the screen sharing option?
Yeah, ma'am. Welcome, ma'am.
It is saying hosts disabled participants screen sharing. I'm not able to share my screen.
Then, ma'am, give permission to ma'am, like hosting.
Yeah, like
Now
I
it's
want,
possible. Huh?
can you make me co-host or host so that I can share it?
1 minute, ma'am.
Just a minute, ma'am.
Yeah. Yeah, I hope my screen is visible.
Yeah, ma'am. Yeah, ma'am.
Yes, ma'am.
Visual.
Yeah, let me go with the quick ride of what is patent and all those things, because you're already aware about it. I'll not waste much of the time on this. So I hope you understand the difference between creativity, invention, and innovation. I would like to have an interactive session. If possible, if you're not able to unmute yourself, you can put across in the chat. Okay, so because most of you have started, as sir has said, like you've already started with your patent drafting and you're in the process. So whether whatever work you're doing, will it be a part of creativity, invention, or innovation? Because creativity is just the act of turning new and imaginative ideas into reality. Invention is creation of a new idea or a concept. Innovation is turning a new concept into commercial success or widespread use. So at what stage are you? Can I have some responses? Are you at the creativity stage, invention stage, or innovation stage? You can just write in the
Creativity,
chat.
ma'am.
Creativity. Okay.
Creativity.
Now, when we are talking about the patent, I hope you are able to see the picture beside this in my slide.
Ma'am. Tree. Yeah.
Yes. So what do you see in this? If I want to see the same thing in terms of creativity, invention, and innovation, what will be the stages? See, if it is just a talk, it will be nothing. Like it's always you are used to listening to talks. But if it is interactive, I can understand at what point and what inputs I can give. So you are able to see the tree?
Yes, ma'am.
Yes. What do you see in this? When I'm talking about creativity, invention, and innovation. Okay, I'll put across in other way. Okay, if how many of you are able to see anything else than the dry tree?
Faces.
Yes, you can see that the freedom fighters' faces are depicted on this, right?
Yes,
In
ma'am.
the same tree, right? So that indicates the creativity. Now, in this thing, what will be the invention? Now, this is something creative. You are having an imaginative one. You are trying to create it. So this one, what I can do with this? Okay. So now when we are talking about invention, I have to turn this, whatever it's an imaginative thing, I can prepare something like a souvenir of this, right? So that is an invention. But this souvenir, whatever I'm preparing, because all of us are become very patriotic when it comes to August 15th or Jan 26th. Other times we are not so much patriotic. Sorry to say that, right? So, but that time, if I'm trying to make this as souvenir and try to commercialize it, okay, so then it becomes an innovation. I can have it as a different model. I can have it engraved on any material, or I can have the same as a poster circulated and given. So that is innovation. So whatever idea you're having, if you're trying to convert it into a concept, that is creativity. But that creativity has to be changed into an invention. But when we are talking about creativity and invention, we are wasting our time and intellectual prop. Okay, so intellect, when these two things are involved, your time should be converted into money. So that is possible with the innovation. So whatever innovation is there, it should be protected also. So with respect to it, now you can see these are two water bodies. What do you understand by these two different water bodies? Anybody? I know it's a long day, might
One
have
is
been yeah.
one
Yes,
is saved
friends.
saved water and one is unsaved water. Unsaved means it came from another source, unwanted. One is wanted.
Okay,
We can
very
say.
good. Yeah, I can say that usually when it rains, we have our streets flooded with water. But same people will be facing like a drought situation in the summer. Why is it happening? Because whatever water you're getting, it is not stored. Whereas if I take the second picture, the water is getting stored. In a similar manner, when we are talking about our intellect, we have many creative things in our mind. But whatever creativity is there, that needs to be protected. See, this is something like you have a flood of ideas, but that flood of ideas need to be protected. So this protection, the walls, whatever we are saying, is being provided by the property right. I hope I am able to convey my thought. So this intellect property is the product or creation of the mind. It is different from other properties in terms that is intangible. Like our tangible properties are your house and all those things. But intellect is something which is intangible, and that is being protected by this intellect property rights. Okay. So with respect to it, already I hope most of you have an idea what is an IPR. It is something which is a result of intellect activity in the industrial, scientific, literary, and artistic fields. So for this purpose, you need to have an IP chain of activities. What are this chain of activities is? First is creation. So all of you are almost in this stage. Next stage is the innovation. Once you have the innovation, once you have a creation, you have to go for a provisional filing. Once the provisional filing is done, then you can have the product being developed and you can go for a complete filing. Once the patent is filed, then you can go for the commercialization. Once it is commercialized, you need to protect it and enforce it. So these are the chain of activities which you need to focus. It's not just about creation, but how do you protect it also is important aspect. So types of IPR, you already have because all of you are doing patent filing. I hope all of you are aware about what are the types of patent IPRs, intellectual property rights. Like we have patent, trademark, copyright, plant breeders' right, utility, geographical indication, and trade secrets. So with respect to it, whenever we are talking about IPR, it is nothing but a bridge between academia and industry. Okay, so if you have the idea, okay, I hope you are able to reconnect both the pictures. One is Saraswati, one is Lakshmi, right? So if you have the intellect, through IPR, you can convert it into money. And this money can act as a catalyst for further IPRs, because through which you will be able to get the amount. So these are the various examples. One is utility patent, plant patent, then design patent, any variation in the existing models. Then you have the geographical patent that is being held by the community. The Kashmiri shawls. This will be coming under the industrial design patents. You can see a small model. You can see there is an optimization of the utility material, but the same you can have the benefit of using it. Okay, these are the various variations you can have in the industrial designs. Then you have the IC layout. Okay, this is something like plant breeders variety. This will come under your trade secrets. Now, when we are talking about the various patents, the most important thing, you have to record your invention. And the most effective way to record an invention is with a notebook. record conception, building and testing, marketing, etc. Rely on sketches and illustrations. And whatever you are doing, record orally with a recorder or a video camera, whatever you have it. Then take pictures of invention, if built, and testing on experimental. So all these things are important because when we go for the patent filing, it will be like across the globe, somebody else may also come up with the same idea. Then in that case, this documentation will help you in claiming that you were the first one to come up with ideology. Because you may have the patent opposition pre-grant as well as post-grant also. For all this, this is a requirement. Now, what has to be entered? Because I said you have to maintain a notebook. What are the things to be entered in a notebook? You have to have the title of the invention. What is its purpose? Who it is intended to serve? Okay. Description of the invention. And most important is the sketches. Always the drawings of the invention is a must. Ramifications of your invention. That is what is the most important distinguished features of it should be also defined. Then novel features. What do you mean by novel features? Uniqueness of whatever patent you are having it. Okay. Then prior art. Prior art is something, because I hope you all know that when it comes to the patent filing, okay. So this patent filing, when you are doing, your concept should be unique throughout the world. But the grant, or you can enjoy the rights geographically. That is, in whichever region you are filing. That is Indian patent, if you are filing, you'll have the Indian rights. If it is Australian patent or African patent, German patent, in that regions, you'll enjoy the patent rights. But it should be unique. Throughout the world, the concept should not be there. So for that one, a prior art search is a must whenever you're starting with your patent filing. And you have to clearly state what are the advantages of your invention, because that is the one which will be letting you depict what are its, where I can utilize it. Okay, application is a must. Then sign and date the notebook every day. And if possible, have a witness size and date also in the notebook. Because witness, when we are saying whatever patent you are having, please do not disclose with anyone except your close ones whom you will be trusting completely. You don't publish your work also anywhere, because if it is published, then it will not be patentable. But once you have filed the patent, and if it has been published in the journal is released every Friday. After that, you can go for a paper publication before the patent grant also. Okay. So procedure to obtain an Indian patent filing. So you have to file an application, filing the complete specification. Then after it is being done, then the examination by the patent office is there. Patent will be accepted and there will be some opposition period, and then you can get the patent. Okay. I don't know what's the problem. Yeah. Thank you. Thank you, Fayaz. So when we are talking about the patent, you have two options. Like when you are coming up with the concept or an idea, you can identify a concept or an idea, formulate that, and always carry out the prior art search. If it is novel, then go for a drafting of the patent. Prior art search, you can do the patent search and the product search. All these different types of search activities have to be carried out. After drafting the patent, one second. One second, I'll be back in 1 minute. Sorry for the break. Okay. So if it is novel, then you can go for the patent drafting. So either you can have a provisional or non-provisional application. So if it is a provisional application, that means the product is not completely produced or the process is not completely defined. Okay. So with respect to it, then title and or the field of invention, background of the invention, brief description of the figures, description of the invention, figures. This will be the content for the provisional application filing. Whereas if I'm talking about a complete application filing, I have to define the title of the invention, the field of invention, background of the invention, the objects and summary of the invention, brief description of the figures, detailed description of the invention. The most important part of any patent drafting is claims. See, there might be same product, but in that product, what you are claiming is the one based on which you will be getting the patent grant. Patent grant is basically about what are your claims, and these are the claims are the ones which provide you the commercial rights. Usually the broader sense everyone has is, the thing is they'll be thinking that if we are going with a good product, then we'll be able to have the product rights. It's not about the product, but in that product, what are the claims that you are trying to make? That is the one which will be getting the patent right. So you have to carefully define your claims in the patent drafting. Then the abstract. So after this is done, whether it is provisional or not complete application, you can confirm the ownership and file the patent application along with the fees and forms. This is an online process. Form 1 is for the application of grant of the patent. Form 2 is for the non-provisional application. That is, I'm not having the complete data. And Form 3 is undertaking any PCT filing if you want to do it. Then declaration of inventorship. There are two things when it comes to a patent filing also. Applicant and inventor. Inventor is the one who tries and does the complete research and comes with the product. If the inventor is also an applicant, that is, now for example, you are a student of MGR. You may be doing the complete research with the research funding from MGR. So now you are the inventors. But if the application is filed by the MGR, then the applicant will be the MGR. And in that, the MGR will be having the complete commercial rights. So if they give a share, then you can claim something in the royalty, or after licensing, you may get some royalty. But the applicant is the one who will be having the commercial rights of the patent. Then after this, you can also go for request for publication, because there are two types of publication. Now, if you go for the normal publication, it takes 3 months. Instead of that, if you want it within 4 weeks of your filing, you can go for early publication. For that one, you have to fill up the Form 9 exclusively. And along with this also, if your product is ready, along with publication, you can also file for Form 18. So Form 18 is for request for examination. Once it is published, your whatever research is there, it will come into the public domain. In the public domain, if somebody has raised a query, okay, or the controller of examiner will be going through your patent, and if he or she finds that this is the question, or already this type of work is there, they'll come up with the queries. So once the FER is being filed, okay, and if you are replying it back, okay, then you have to file a reply. Once you get the FER, after that, within 3 months, you have to give the reply. you can have some more extension time of 3 months. But after 3 months, if you are not responding, then the patent will lapse. So once you give the answers to the queries, then you will be having the filing of the patent will be done. Then the prosecuting through the patent office will be carried out, and the patent will be decided whether to be granted or not granted. And this will depend upon pre-opposition also. If you have any pre-opposition, then you have to clarify that also. And every patent after filing from the 3rd year, you need to pay the maintenance fee. It might be you get a grant or may not get a grant, but from the 3rd year, you have to start paying the maintenance. Until that is, you have the patent right. That is, if it is an utility patent, it is 20 years. If it is a design patent, it will be 10 years. Copyright also, it is for the 8 years. So depending upon what type of IPR you are filing, accordingly, you will be going for its maintenance. So these are the various forms. Okay, you also have to give an authorization for a patent agent if you are filing through a patent agent through Form 26. Why is it so important to deal with a patent agent? Because when we are talking about the patent, it is a techno-legal document. Now, when we say techno-legal document, we need to be very precise about the terminology that we are using in that particular drafting of that patent. Okay, so technically we might be very sound and very innovative, but the same thing when it comes to the drafting, you have to be very careful about it. For example, if I talk about any equipment, okay, what could be my sentence when I'm writing it? It can be the machine consists of, okay, or the machine comprise of. Is there a difference between the two sentences? Is my query clear? Okay.
If anybody has query, ask to ma'am regarding patent, we have forum number.
I hope I'm able to make. Can you make a difference between consist and comprise? If I want to talk about any machine, okay, you have already dealt with, I don't know how many of you are from which streams? What is your background? Anybody from CSE?
Most of them are CSE, ma'am.
Okay. Okay. How many of you are from EEE or mechanical? Any core branch?
I am from civil.
Civil. Okay, good. Okay. So when I talk about it, for example, if we take about a computer itself, because most of you are from computer background. Computer use when I'm talking about the patent drafting. Are they both same or different? You can write on the chat. Are they same or different? Or you can unmute yourself and we can interact. Okay, I hope you all know what are the things that are there in a computer, right? You have a motherboard, then you have a RAM, all those things, right? So when I talk about describing that, I can say that my computer comprise of RAM, okay, or it can be motherboard, all those things. Or I have to write my motherboard consists of, which sentence would be right? Any tinkering in your heads? I hope I'm able to put my question clearly. Okay. Now, when I talk about, as it is, if I talk about in general English, comprise or consist mean the same. But technically they are correct. But legally, when I go with it, if I use the term consists of or comprise of, when I use the terminology, then in that case, I will not have a provision to add up some more things in it. So I'm restraining that it should comprise. That means this is the limit. Whereas if I say it consists of, then if I say it consists of, right now my consists means, right now I may have 8 GB RAM. I may change it into 16 GB RAM also. That flexibility will be there. But if I mention that it comprise of 8 GB RAM, then I cannot have that flexibility. So this is where the legal terms, when you are drafting, you have to be very careful with the terminology. You have to be clear what is the difference. Okay. So I hope you understood what is the importance of drafting, why it is important to focus on techno-legal terms. Okay. So this is about the time span. If I'm talking about just a provisional filing, it will be 12 months. If it is to be published 18 months, this 18 months can be cut short to 4 weeks if you are going with the complete filing and early publication. Then request for examination can be done within 4 years. This can be cut down to 3 months. If you are filing along with the provisional filing, you are filing even Form 18. So it is all about how you are planning whatever project you are doing, how you are drafting it, how you are coming up with the end result. This is the one based on which you will be cutting short the time. Okay. So after an FER submitted, you may put an application for the order for grant. If it is accepted, you may also, if it is not accepted, you may go for a second hearing, then refused, or patent may not be granted also. So this is the complete process. Now, after this, now when we are doing this patent drafting, it's important that we carry out its search. The purpose of the search is to find out what is the scope for the search and selection of the keywords. So if there are various Google database or patent databases under which you can carry out your search. One of is your Google Patents. You can have the WIPO or Indian Patent online, you have it. On this, you can carry out your search. So it depends upon the selection of keywords. So when I say, if you do it, like just if you type it, I want to do a patent search on about the red pen, then I'll get number of documents. If I change it, the keywords, red ball pen, then my search numbers increases. So it is important that I have a precise selection of keywords and based in preparation of the search queries, and then searching and all should be done, and data extraction has to be carried out. From this, I'll be able to define properly my patent, what is my patent problem. So the base for the patent writing is stop others from making, using, or selling my invention. So things that your owner should do is exercise the license, sell it, trade, pledge, promote it. And why do you need to do patents is to have the new ways to make it or to find its new applications. Okay. And the invention should be useful, it should be novel and inventive. And most important is it should be commercialized. Okay. So when you talk about the patent, you have to describe how to make it and how to use it. Claims are claim what's new, inventive, and useful. As I said, the most important thing in a patent document are your claims. Now you can see.
Ma'am, it's
everyone,
possible in bargaining, ma'am, in patent. It's possible. Bargaining means changing copy paste from another source. That's it, na bargaining.
No, no.
No.
That's what I said. Like you may be having the same thing, but in that your innovativeness should be there. Okay.
Ma'am.
Because in a market, if you're going, the same tomatoes, if somebody is purchasing, they may ask for 100 rupees, but you may go for a bargaining and say that you have to give it for 60, then only I'll take so many. So that means you're bringing in your ideology in that, right? So similar way, whatever existing is there, in that existing one, you add up your own thought process. And thereby you can go for the patent filing. So everyone knows about scarecrow, right? You know it or you haven't been?
Ma'am?
You know a scarecrow?
A scarecrow? No.
Where do you use a scarecrow?
Scarecrow, I don't know.
In the fields we use it, right?
Screw,
In fields, farmers use a scarecrow, right?
That's it. Ma'am, that's one.
Yeah. Why do the farmers use the scarecrow for? To ward off the birds and all from damaging the field, right?
Losing, damaging. Yes,
Yes.
I'm losing the film.
So this scarecrow concept, is it a new one?
No, it's very variety, man. It's now it's in a market. It's a various type.
Yes. Now, when we are talking about the scarecrow concept, the same thing, as I said, like tomatoes. Now, when we are talking about this, you can come up with the same concept of the scarecrow example. But this is with a respect. You may have a sprinkler, you may have a sensor head, and to scare, you may have a sound making mechanism. Okay. So all these things, the innovativeness, the same, we have a standing and a thing is there like a stand, but the purpose, how you utilize it, and thereby the purpose of it will be defined. Okay. So it's important. It's not like you come up with a very big thing, but whatever you're doing, there should be an innovativeness. I hope you know the jumper clip also, right? So in 1880s, it was filed for patent. When it was filed, what is the terminology that was used? It's just a clip that you keep it for the papers, right? But when I use it in the documentation, I'll use the terminology as it's a device which holds the papers together under the action of pressure. So this is technically, it is like you're saying that under the action of pressure, you're trying to hold the various things, right? So it's important what are the terms that you're using. Okay, even how many, most of you use the Coke can, right? So in the Coke can, the opener that is being utilized, that is also a patented one. And the one who has come with that, just how to open that, has earned billions of amount. So it all depends upon whatever small variation you're coming up with it. It should be innovative. Okay, a patent validity, a patent claim is valid if we define something that is new and inventive compared to the current body of knowledge, but without describing any embodiment of the current body. Before I go with the validity and patent, this thing, let me share another document. I hope this screen is visible.
Yes, ma'am.
Yeah. So when it comes to, as I said, in the patent drafting, the most important aspect is the claims, right? So how do you carry out the method of claim construction? Define the invention and what are legally enforceable. The claim or the claim shall define the matter for which the protection is sought. Claims shall be clear and concise. they shall be fully supported by the description. Because in the patent drafting, you are not drafting about the complete process, but whatever claims you are trying to make it, that claim should be supported. For that particular claim, you try to file the drawings. There is a drawing methodology also, in which the numbering, you will be having a different numbering system. The numbering should be referred, and this will be a separate document altogether, the drawings. And the role of specification and claims is, the claims define the legal boundaries of the invention. Must claim the invention with reasonable precision, because it might be the same thing, but in that, what is that you are claiming is the one which makes you whether you will be able to get the patent granted or not. For example, take case for myself. Pneumatic quad robot is the one which is existing all over, right? You have the Boston developed it and all those things. But the same pneumatic quad robot we have tried to develop with the simple mechanism system. So I have not claimed about pneumatic quad robot, but I have claimed about the cost and the mechanism, the movement. So what you are trying to claim in that, that is the one which will be able to let you get the patent grant. The specification describes the invention and how to make and use it. The written description requirement, okay, embellishment requirement, the best mode. The simple approach for this is write claims to the intended audience. Now, if I want to talk about any patent, okay, how it will be useful for somebody else. For example, I've talked about developing of a biodiesel production. Okay, so biodiesel can be produced by any Jatropha. There are various ways of production. But now what I have said is, my biodiesel which is being produced is from the waste cooking oil. And the efficiency, the yield rate is 95%. With this 95% yield rate, whatever leftover is there, I can reuse the catalyst once again. And this will be at par with the diesel that is being used in the engines. That is being tested. So thereby I'm saying that the automobile industry are my intended audience. Based on this, what are my claims I'll be saying is, my yield is high, and thereby I can say that the catalyst can be recycled, which is sustainable. The byproducts can be utilized for some other purpose. So all this, it's not about just production of biodiesel, but be specific about what you want to claim in that patent drafting. Use plain English, fully and clearly supported and defined in the specification. Every term in a claim means something. So every terminology, every number that you put across in the claim should be proved and should be very authentic. The scope of the patent is, the prohibition against new matter will prevent you from introducing further description after filing. Okay, so whatever, that's the reason we say like go for initial provisional filing, because once you are going for complete filing, in that I cannot add up few more things in that. I cannot add up any other claims after doing my testing and all that. Once the filing is done, I cannot go for any changes. Okay, I can add up the claims only during prosecution. Okay, but must be supported by the specification as filed. Specification means I have it in the IPC, the Indian Patent Classification System is there. If I'm doing some chemical thing, biodiesel may come under chemical, whereas robotics can come under the, it depends upon where I find its application, electromagnet, mechanical. So it's all depends upon in which classification you are also specifying. where you are specifying. All this needs to be defined prior. Continuation in part application may contain added matter. Claims may not be entitled to earlier filing date. Okay, you need to follow this grift. That is getting it right first time. It's not like in a patent you have a trial and error option. Once filed is the final filing. So when you are filing, make it file in the right manner, right purpose. Okay. How to start drafting? Draft a set of claims first to define an invention. It requires an understanding of the content of the prior art. As I said, prior art is something, it is the search that you carry out before drafting your patent, and an understanding of what makes the invention patentable. So it's very important before you start your drafting of your patent to do a prior art search. There are various tools that are available for doing this prior art search. The specification is drafted in view of the necessary content. First drafts don't have to be perfect. They just have to be written. So once you write it, go through it after 2 days. You'll find something else. Redo your work. So that's the reason I said, like, maintain in notes. Write the date and time as you refine it. After you feel that further refinement is not possible, go for it. Parts of the claim, permeable. That is, it should be short and should not imply any unnecessary limitations. As I said, don't say comprise. That will limit it. Instead, I can say that it is consisting of. Transition terms, comprises, okay, encompasses additional elements, consists. It encompasses additional elements that do not affect the essential features of the invention. Okay, consisting of does not encompass additional elements. So all this terminology is very important in your techno-legal document. Coming to the body, recite all the essential elements, components or steps and their limitations. Relate the elements to each other. Okay. Coming to the drafting of claims, we have to draft at least one independent claim for each type of patentable invention. That it can be a product, process, apparatus, whatever it can be. So you need to identify what are the potential infringers and products. The claim should be drafted so as to maximize enforcement on direct infringement theory. What is this infringement? I'll just cover it. Draft dependent claims to help define broad terms in the independent claim. Create fallback positions, commercial or preferred embodiments. So as I said, what is infringement? To that, let us continue with the PPT. So as we have already clear about what is the patent claim, I'm not further discussing about. Coming to the infringement, a product infringes a patent claim if the patent includes all the elements set forth in the claim. If the product includes all except one of the claimed elements, it will not infringe the claim. If the product includes all the claimed elements, but additional innovative or non-innovative elements, the product will still infringe the claim. So it's important, like what I want to claim. And in that, whether I'm trying to cover all these elements is important. Okay, a broad claim is more likely to capture competing products as infringement, but is also more likely to be ruled invalid as capturing existing technology within its scope. A narrow claim, if I'm trying to do it, is less likely to capture competing products, but is also less likely to be ruled invalid. So it is more important about whether I'm making a broad one or a narrow one. The terminologies, the sentences makes very important. Patenting is a waste of time and money unless you have clear answer to the two business questions. Validity, that is, what precisely have we invented? Okay, if this is not answered, what is its application? What is its commercialization? Then there is no use in going for the patent filing. Infringement. What aspects of our invention do we want to prevent others from using without our permission? What aspects of an invention are strategic for the organization? What aspects of the invention will be a marketplace deemed valuable? Okay. So because it's time up, so I'm just closing. If there are any queries, we can have a further discussion. Any queries from anyone? How many of you have utilized the patent search? Can you just raise your hand? Okay.
From my
Niranjan,
college, 10 members, ma'am. 10 teams, ma'am. In each team, 5 to 6 members from each different department.
okay.
12 team is there, but 2 team is not working till now, but 10 team is working.
Okay.
All
You have
have
done
a
your
different
prior,
proposal.
yeah,
Yes,
you have
ma'am.
done your prior art search already.
Ma'am,
You have done your prior art search.
some teams done, some teams searching.
Okay. Because before going for patent filing, it's very important to do the prior art search.
Priority. Okay, ma'am.
Yeah.
Thank you, ma'am, for wonderful presentation. I believe your guidelines will be helpful and valuable for our students and me also. If anybody have a query regarding any patent, then kindly ask ma'am.
There are only two options possible. Either it is clearly very much understood or it is not understood.
Dear team members, dear team leaders, kindly ask if anybody if any have any issue. Yeah, text your question in chat if you have issue to talk. Okay, let's move on. Thank you, ma'am.
Yeah.
Now I call Dr. Deepa ma'am, a student's patent coordinator, to convey the vote of thanks. Deepa ma'am.
Yes, Fayaz. Am I audible?
Yes, ma'am, audible.
Thank you, Fayaz. Good evening, everyone. Myself, Dr. Deepa, working as Associate Professor and Deputy Head of the Department in Department of Civil Engineering. And for the past 3 months, I have been the Head Coordinator of Edison Student Patent Forum of Dr. NGR Educational and Research Institute. No duty is more urgent than that of returning thanks. It's my privilege to propose the vote of thanks on this occasion on behalf of Joint Registrar EPA Office, Dr. NGR Educational and Research Institute. I extend my sincere vote of thanks to all gathered here for this workshop on patent drafting. Let me first of all start by giving glory to the Almighty God for making today's event a resounding success. First and foremost, I thank our Honorable Chairman, Thiru A.C. Shanmugam Sir, and President Engineer ACS Arun Kumar Sir for giving us the permission to conduct this event. We are extremely thankful to today's guest speaker, Dr. Ishrat Meera Mirzana, Professor, Mufakam Jah College of Engineering and Technology for having spared her valuable time and have given so much valuable inputs, which will really be beneficial for the faculty and students to publish and find more and more patents from MGR Educational and Research Institute. It's really wonderful workshop, ma'am. Thank you so much. We are very thankful to our Joint Registrar, EPA, Dr. L. Ramesh, for being the pillar of support, for his kind support and valuable guidance throughout all the events organized from JREPA office. Thank you, sir. I wholeheartedly thank all the teaching and technical staff of JREPA office for their valuable support. Last but not the least, I thank all our students and participants for your cooperation in making this workshop successful. I once again thank you all. Thank you.
Thank you, ma'am. 1 minute, ma'am. Now we have photo session with Dr. Israt Mirzana, ma'am. Kindly members open your, if it's possible, open your camera.
Sorry, Fayaz, I can't
Okay,
able
okay,
to
no
open my camera.
problem. Those who are applicable, kindly open your video camera. Thank you, Anumi, ma'am.
Yeah. Thank you all for this opportunity. Looking forward to work with you all. Thank you.
Thank you, ma'am.
Thank you, ma'am. Thank you.
Thank you.
Fayaz, can we leave?
Yeah, ma'am. Now we are going to.
Thank you, Fayaz.
Thank
Thank you.
Thank you all. Thank you.
Thank you, ma'am.
Thank you, ma'am.
हमने से बात कर दे रहे थे, ठीक है। पापा का पापा मिट्टी वाले रोज पापा का पापा मिट्टी वाले